This meeting 2 of the Senate Standing Committee on Education will come to order. I'd like to welcome everybody, members and guests. If you would please silence your phones. Unfortunately, we do not have an overflow room today, and we do need people to really can't stand in the aisles. You need to. We can't have anybody standing by the doors. The doors need to be closed. So you can maybe a few can come up here, and some can stand in the back wall, but we have to cut it off. I've asked for an additional room, but we're booked and there are no rooms available. Other committees are in order or in session, so we can't. We did the best we could. I would also like to, at this point, talk about procedure and process. Anyone can speak in the committee, but you need to sign up on the sign-up sheet, and it's over in the corner. And I've left open the first 2 minutes of the meeting where you can still sign up, and we will take that up. So you've got about 2 minutes to sign up if you want to speak for or against a bill. There are no signs permitted in the committee room, so those are prohibited. Do we have, also, we are implementing a new rule. This affects committee members, not constituents or presenters, but when we're doing a vote explanation, if you could, please limit that to 1 minute only. If you want to speechify and make comments, please do that during the question and answer portion. And so we can we know what we're doing and we can keep everything on time. So do we have any members that have special introductions? Senator Thomas.
Thank you, Chairman West. I'm pleased again to see so many of our educational instructors and professionals here from the Fayette County Schools. I would ask those teachers to stand as I mentioned their schools today. I have teachers from Tates Creek Elementary. Please stand. Mill Creek Elementary. Please stand. Cardinal Valley Elementary. Michelle, I know you're here somewhere. You stand. Deep Springs Elementary. Brunswick High School, my alma mater, is represented today. And Carter G. Woodson Academy. Okay. I want Chairman West to applaud and recognize these teachers here today from Fayette County Public Schools and give them a warm welcome.
Senator Givens.
Mr. Chairman, thank you. I was honored to have a young lady reach out to me on an issue here about 2 weeks ago, and in the process of the reply, it became apparent that she's a talented mother of 2, passionate about lots of things in her community, and I encouraged her to come down and shadow for a day. And I'd like to introduce Miss Tanya Whitfield. Tanya, could you stand and wave to the group? Honored to have Tanya shadowing today.
Yes, Senator Frankie Vermeyer.
Yes, and I wanted to recognize 2 young ladies who are very passionate about learning and making the most of their college education, their college experience. I have Dea Smith here from the University of Kentucky, who is interning with me during this legislative session, and Callie Antle, interning from Northern Kentucky University for this legislative session. Thank you.
Yes, I have a group that I'd like to present today. We have, I saw them in the back, the Harrison County group back there. If you could please stand. They weren't expecting me to say this, I know. We have Mayor of Cynthiana, Chamber of Commerce, and others. Welcome to the Education Committee. You can now see how this all operates. Thank you. Okay. I just got a note. We do have overflow now. We have an overflow room 154. So if that could be announced outside, we do have an overflow room 154 until 11:50. Now that the introductions and initial things, Senator Meredith. Sorry, Senator.
Sorry to interrupt you, Mr. Chair, but I have a group of educators from my home district of Breckinridge County and Grayson County, and I'd appreciate if you folks would stand up and be recognized. Thank you. And excuse me, another group just snuck in. It's a group of high school students from Breckinridge County High School that's over here to my left here. Welcome them as well. Thank you.
Secretary, please call the roll.
Senator Carroll. Senator Carroll. Senator Funky Fromeyer.
Present.
Senator Givens. Senator Higdon. Senator Meredith. Senator Neal. Senator Stivers. Senator Thomas. Senator Tishner. Senator Wilson. Senator Wise. Senator Williams. Chair West.
We have a quorum and we can conduct business. We have a busy agenda today, so we'll go ahead and get started. If Senator Givens would come forward on Senate Bill 70. You may, yes, sir, you may present from the podium.
Mr. Chairman, thank you. And with your permission, I am going to present from the podium here regarding Senate Bill 70. This is a piece of legislation that I've had in the past and got caught up in the midst of COVID. I like to characterize this as flexibility, innovation, and meeting the needs of our professionals, our educators, while maximizing the value of their time. What Senate Bill 70 effectively does, it recreates, again, I use the word recreates because this is something that we've done in previous language. It recreates, renews a 3-year pilot program for those professionals in our school systems, the educators, to, with the help and input of their local board, design their own professional development. So this can be strategic if teachers in our school systems have special needs for PD training around some topic. They have to collaborate with another teacher. They have to design this in such a way that it's robust enough to qualify for 3 days of the 4 days of professional development that they're required to get every year. It also has to be approved by the local board using the parameters seen in the current language. With that, Mr. Chairman, I would gladly entertain any questions members have.
Thank you, Senator Givens. We are open for questions on Senate Bill 70. Seeing none, we'll move to vote.
I will make a motion on the bill.
We have a motion on the bill. We have a second. Please call the roll. We have a second. Please call the roll.
Senator Carroll. Senator Funky Fromeyer.
Aye.
Senator Givens. Aye. Senator Higdon.
Aye.
Senator Meredith. Aye. Senator Neal. Senator Stivers. Senator Thomas. Aye. Senator Tishner. Senator Williams.
Aye.
Senator Wilson. Senator Wise. Aye. Chair West.
Aye. Ten aye votes, 0 nay votes. Senate Bill 70 passes with favorable expression. Thank you, Senator Givens. Next up, we have Senate Bill 66. If Senator Meredith and others would proceed to the table. While they're coming forward, I would just like to mention, I think we have people to speak against the bill. If you would wait just a moment, we'll let Senator Meredith make his presentation, and then those opposed will step in. If you could say your name for the record, and please proceed.
Would probably prefer to be incognito today, but I'm Senator Steve Meredith from the 5th District, which is comprised of Meade, Breckinridge, Grayson, Ohio, and Butler counties. I'm proud to represent them. And
I'm Vicki Yates Glisson. I'm a healthcare and health insurance lawyer that practices out of Louisville, Kentucky, and I also have served as the former secretary of the Cabinet for Health and Family Services. Thank you for allowing me to be here today.
Thank you. Please proceed.
Well, thank you, Mr. Chair, members of the committee, for the opportunity and privilege to present Senate Bill 66 for your consideration today. As many of you are aware, our public-funded colleges and universities have been delegated responsibilities through various state statutes for both collecting data and being the repository of said data. Additionally, as research universities, there have been many instances of requests of them to analyze the data for the benefit of our Commonwealth, which they've done an excellent job. But even though we recognize our major public universities as our premier research facilities within our state, they do not and should not be the sole source of research efforts within our Commonwealth, nor have exclusive access to the data that they hold. The intent of this bill is pure and simple, and that is to mandate our public universities to allow reasonable and timely access to data which are owned by the citizens of our Commonwealth. Now, I personally have heard many anecdotal experiences of difficulties from various individuals and groups and state agencies in their efforts to gain access to data owned by our Commonwealth, held by our public universities, so I can only speak in generalities about the problems and the issues. Or I'm sure maybe the public university's position, which you already know, they would probably be testifying against us today, that they would probably say there's a perception of a problem with this situation, but in either case it needs to be addressed. So in order to speak about it in more detail, we have invited former Secretary of the Cabinet of Health and Family Services, Ms. Vicki Glisson, to share her personal experiences as difficulty when she was in that office and also being in private practice. And with that, I'll turn the rest of the presentation to Ms. Glisson.
Thank you, Senator Meredith. I appreciate this opportunity to come up and talk to you. Senate Bill 66 creates a new section of KRS Chapter 164 that provides that data that is provided to a public university by or on behalf of a state agency shall be provided back to that state agency upon request. It also provides that a non-state entity to become eligible to request and receive access to state data if the data is being sought for research purposes and is subject to an institutional review board, an IRB approval, or that request meets the certain limited data set requirements under federal law. IRBs are closely regulated by the FDA, which is an agency of the Department of Health and Human Services in Washington. They were formed in 1974 and were formally designated to review and monitor research projects. The purpose of an IRB review is to assure that both in advance and by periodic review, that appropriate steps are taken to protect the rights and welfare of any individual that may be part of a research project. A limited data set. A limited data set is a limited set of identifiable patient information as defined by the privacy and security regulations of HIPAA and other federal laws. Under HIPAA, for instance, a limited data set of information may be disclosed to an outside party without a patient's authorization if certain conditions are met. First, the purpose of the disclosure may only be for legitimate research purposes, for public health issues, or for healthcare operations. Second, the person receiving the information must also sign a data use agreement that meets the stringent restrictions that are part of federal laws and statutes. Essentially, all facial identifiers, things such as name of the patient, address, social security number, anything that might allow you to maybe identify that individual, are stripped out. Only information that remains in a limited data set is essentially almost like aggregate data. It's de-identified essentially. You have the date of admission, you may have a date of discharge, you may know what the service is, the date of birth, the city, the county, or the city and the state, not even the county, the city or state, zip code, and age of the person. The state's public universities receive and store an enormous amount of data, state data, through contracts, statutory and regulatory mandates, and research arrangements with our state agencies. These arrangements can serve a very beneficial purpose. This bill tries to address the fact that there are public universities, that as public universities, these entities are essentially the state's vendor to store our data, to store the citizens' data. However, I am here today to ask that this legislature address the issue of a lack of access to this data by state agencies and appropriate researchers when it is provided to public universities. The lack of access to our own state's data has very negative ramifications for our state agencies, for healthcare providers, research, and patients. I experienced this problem firsthand when I served as the Secretary of the Cabinet for Health and Family Services. I'll give you an example. Shortly after I walked into the doors of the Cabinet, I was notified that it appeared that we had children in some counties in eastern Kentucky that may be experiencing significantly higher rates of brain cancer. I immediately began to try to identify the data within the Cabinet to help me assess, is this an issue? Is this a problem? I learned almost immediately that all needed data resided with our public universities, either through contracts with the Cabinet or through statutory arrangements or mandates. As Secretary, I had no or very limited access to any real-time data, even aggregate data. I reached out to the Kentucky Cancer Registry. I was advised that the information in the registry is owned by the university. The university finally conceded that I could ask a question, and that took a lot of persistence on my part. I could ask a question, they would cull through their data, and that I should wait for them to get back with me, but that the Cabinet could not have real-time access to our state's data so I could make an informed decision. After learning that the Cabinet would not be allowed to access this and other types of data that reside within the universities, I looked for and I offered many solutions in order to try to work with the public universities to be able to get the needed data that we were denied. I continued to be denied access to that data. I soon learned after returning to private law practice that clients who had made requests to the public universities to access data for the purpose of performing research projects under the oversight of an IRB or through the use of HIPAA or other kinds of privacy and security compliant options, they were denied the ability to be able to validate treatment models for the populations that they treated. This occurred even after lengthy discussions that clients had with the universities in order to try to find ways to access this data. One of the research requests would have allowed providers to be able to validate treatment models to address improving the quality of care for our state's disabled individuals. Validating models for one of our most vulnerable populations would be of significant benefit to that disabled individual and to the families that are struggling to provide care for that loved one. Another research request was to validate a certain treatment model for individuals suffering from substance use disorder. Again, a public university had this information through a contract between several of our state agencies and a public university, and they were to store these outcomes data on this certain SUD model, but again, access was denied. Identifying and confirming effective models of treatment for substance use disorder would be very beneficial to our state as our state struggles to determine the most effective ways to address this overwhelming problem that we are facing. You as legislative members regularly ask state agencies, you ask me as the secretary many times, for quantitative data to confirm outcomes. What are we paying for? Are we getting results? And that's the right question to ask. However, in order to confirm those outcomes, you have to be able, and to be able to make informed decisions, you have to be able to have access to data, and you have to be able to do your data analytics on that data. This bill will remove the barriers that have been put in place that will allow state agencies to access their own data. So as a secretary, I could get that data that is the state's data that I needed to have to be able to make an informed decision. And the agencies that, and as well as the former secretary, must let you know, I felt like at many times I was flying blind. I felt like I can't give the information, I can't be responsive to your questions. State agencies need access to this data, or otherwise you can't make appropriate decisions. This bill also removes barriers so that researchers, folks that we need looking at the state's data, as long as it's done under federal and state laws and regulations, and those are already in place. It allows those folks working under an IRB, that's part of that is regulated and overseen by the Department of Health and Human Services, or by using the federal laws that are out there to protect privacy and security, that they can have access to our state's raw data, not anybody else's, only the state's data, that is being stored at the universities in order to validate treatment models and to prove our health care in Kentucky. This bill merely gives the state access to its own data that is being held by a vendor where our data resides, and it provides access to raw state data to researchers that are performing research projects under the oversight of a federal IRB or under the requirements of a limited data set using the laws that are there to protect the privacy and security of all individuals. I did want to make sure that you knew that once this bill was dropped, we immediately went to particularly the University of Kentucky, because a lot of this information is held by the University of Kentucky. And we wanted to make sure that we gave them notice that we are working on this bill and the issue we're trying to address. And I just wanted to assure you that we have reached out numerous times since then asking to work with them. We have not been able to get any feedback about if there is a concern, because we understood just generally that they had concerns, and we were like, please let us know what your concerns are. We want to try to address those concerns if we possibly can. We even asked to try to be on a call today. If they said that they did not have time to get here before this hearing, we asked if we could even talk on the phone on their way here to the hearing, and that was not available to us. We did meet just briefly outside the door because I stood out there kind of waiting to say, I want to make sure I understand what your issues are. And because I think they're going to be testifying, and I'll share with you what they told me, and then I want you to know our thoughts. First, they said, this isn't necessary because we've been filling requests and we have had no complaints. Secondly, they said that the state doesn't need this because it's going to conflict with state or federal laws. And as I told them, we can place something in there if you need that. It should go out. It should be, that is not an issue because you cannot violate state and federal laws, and it should go without saying. But, if you want us to put something in there that states that we're not going to conflict, that we will not violate state and federal law, we're glad to do that. They also said, well, we don't know what kind of an IRB. The reality is that IRBs are housed, whether they're a professional IRB or whatever that IRB is, it is regulated by the Department of Health and Human Services, by the FDA. They have to meet stringent standards, and everybody is using the same criteria. If we need to do something to place something in there that says that is reassuring, we're glad to do that. So what I heard were all things that I thought, we're glad to say that we're not going to be violating state and federal laws, if you want us to put that in there. And we're also glad to say that if you want to put something in there about, that it is a federal IRB under the Department of Health and Human Services or whatever, we're glad to do something like that. I just urge you to pass this bill out today. If you would like, we're glad to meet with the universities in the meantime, and because I didn't hear anything that was insurmountable that we could not address. So thank you very much for allowing me the opportunity. It helps me to kind of get it off my chest. It worried me when I was the Secretary of the Cabinet, and I'm glad for the opportunity to let you know and to think that we're going to be able to address this issue. Thank you.
Thank you.
Ms. Glisson recognizes that part of our job is counseling of people, so we appreciate affording you this opportunity today. But obviously, he has a lot of passion regarding this, and I do as well. And I've heard from numerous people since we filed this bill, individuals, mostly in the medical community, that this is an obstacle, particularly for our oncologists. They just can't get the data to provide effective care and continuity of care, so that's a struggle. This is a bill probably we did not want to file because we think there is some reasonable exit points on this that we can hopefully work this out. But if not, I think we'll have to explore some other options, possibly is looking at another area that we could make this repository for this data. Maybe this is going to have to become a division of state government that we set up in our health and analytics, that we collect this data here so everybody will have equal access to it that's needed. But again, I recognize the work that our research facilities do. They do a wonderful job. But in the society we have today, we need as many people looking at these issues as we possibly can, particularly when it comes to medical issues. As you folks well know, we don't score well on any areas when it comes to health of our Commonwealth. So again, I think this is a reasonable first start for us. And again, we would entertain the passage of this bill.
Thank you, Senator. Thank you, Secretary Glisson. We will open the floor up for questions. Senator Carroll.
Thank you, Mr. Chairman. I understand what the bill does. Is there a need to put something within legislation on contracts to put this type of language in the contracts up front to prevent this from happening, to make sure it's clear up front on who has access to the data?
She's nodding, but I would agree. I think that's a very reasonable request to make, and should be part of any agreement we have with any entity that has access to our data.
And Senator, in looking at what other states have done, there are a number of states that do address this issue in their contracts. Because what I was faced with was I was getting feedback from the university saying, I need you to, before I even talk to you, I need for you to confirm we own this data. I said, no, you're a vendor. You're a repository for this data. And so I would not sign those documents. But many states, to your point, you're exactly right. We need to start dealing with this appropriately. So there's not a question. You don't put a secretary or others into that position to have to get into that fuss. Thank you.
Thank you, Mr. Chairman.
Senator Thomas.
Secretary Glisson, I'm going to try to minimize my words today, but in reading this particular bill last night, I didn't see anything in here that restricted confidential information. I mean, I know you mentioned that, but one has to read these bills, and I always remind us as if they were becoming law. And as I read data, there's nothing in there that restricts personally identifiable information. And let me give you an example why I asked this question. As all my colleagues know, I had a wife who died from cancer. Okay, she was in the Marquis Cancer Center for about a year. Okay, and part of the funds she received was from a state institution, Kentucky University. Part of my medical insurance was paid for by K-State. Okay, so as I read the definition of data in here, if you wanted information about cancer patients who experienced oncology and died, you could conceivably get information, personally identifiable information about my wife, the way this is written. And so that gives me a great deal of concern, I must be honest with you, as to why that should be disclosed under any circumstance.
Thank you, Senator Thomas. I have a couple of comments. First of all we're asking in this bill is the state is able to access its data. So it's not asking for any kind of patient data that may be housed in a hospital or whatever at the University of Kentucky. This is just it's a pretty narrow definition. This is just the data that the universities may have pursuant to a conflict pursuant to a contract or pursuant to some type of a statutory mandate. So it doesn't touch that information. Secondly, quite frankly, and I think Senator Meredith sort of touched on this, but no one can not even the treating physician can get to your point about your wife being at the University of Kentucky and getting cancer treatment. My husband is an oncologist and a hematologist. He struggles with this issue almost every day. He cannot believe, and that I don't want to get us off because that is a whole separate issue, but you just need to know that information that is sitting in the Kentucky Cancer Registry is not even accessible to a treating physician or the patient because the university says we own that data. And so hospitals will destroy their medical records after 10 years because that's all they have to keep them under to be licensed. So whenever a patient comes into my husband's practice and says, hey, doc, 15 years ago, I had a mole taken off and it looks like it was probably precancerous, he will say to them, what type? What stage? What medications did you receive? I don't know, doc, that was 15 years ago. It's in my medical record. No, I can't get it. It's in the state cancer registry, but not even I, as your treating physician, nor you as a patient, who is supposed to be able to now, under our laws, be able to put together their own personal health record so that they can go into a doctor's office and say, here's my information. They can't get it. And so he says, I have to tell you that there are certain medications that I can only give you one time in your life. Did you get this medicine 15 years ago? I don't know, doc. So our doctors are also flying blind. But that is a whole separate issue. This is only asking for the state's data that a state agency can get it back. And if you have someone that wants to do research, that person, under these strict laws that are already in place on a federal level with an IRB that is administered out of the Department of Health and Human Services, and all federal privacy and security laws will apply. And that IRB will never allow anyone to be able to do a research project unless they have specifically met every state and federal law or regulation. Otherwise, all we're saying is, I, as a secretary, if I needed information, I should be, and anyone else that's in a state agency, they can get that information so that we can try to make better and informed decisions.
Senator Givens.
Chairman, thank you. As I read the legislation, one of the questions that comes to my mind is this limited? A lot of our conversation has been around healthcare data. Is this limited to healthcare data only?
No.
Okay.
No, and that's what's kind of peculiar about the situation is the repository of a lot of different databases for the state. Again, it's our data. We ask them to hold it, keep it in storage, but as soon as we do, it becomes their data, which we don't have access to. So no, I think the most egregious part of this is related to healthcare, but no, there's many other things such as educational information outcomes that we just aren't privy to.
So my question that follows, and this is let me assure both of you that I've not talked with anybody from any institution, university or otherwise. So what I'm going to share is a totally fictitious example, but walk me through this because this is one that I think could be real. Senator Meredith, as you know, in Bowling Green we have the ICSET Center, the Innovation and Commercialization Center, and they do a lot of really neat work in public-private partnerships. And suppose that they're engaged in a metals refining and strengthening research project. They're in a combination of a public institution that's got 3 or 4 large private corporations that have hired them, contracted with them for purposes of researching this question on how to make metals lighter and stronger, something like that. It's a proprietary sort of situation where these entities that are investing their private capital are wanting this research information for the purpose of advancing their projects specific to their industry and their brand. Are we now walking into this space and saying the work that's done has to be publicly shared, despite the fact that this entity is coordinating a contract with the institution for proprietary information?
No, I don't think so, because again, we've got this fine line as to what's public, what's private, and I think any research that any university does that results in some type of product or service that's proprietary for them and would not be accessible by anyone else.
So expand on that for just a moment, if you would, because I see the word including outcomes data here on line 22, and maybe that's the part. A public university shall provide data including outcomes data. I'm not disagreeing with you. I'm just trying to know where that security fence is that says after WKU ICSET has done the testing, refined the product and nailed down this innovative metal, the fence that prevents them from having to provide that outcomes data to everybody that asks.
Well, I think the question before the university as to what data we're requesting would answer that question, because we're looking at it in the aggregate. We're not looking for specific results, and those outcomes are more global in nature. Again, recognizing their role as a research university, developing their own products and services as a result of that, I don't think is affected by this at all.
Thank you.
Seeing no further questions, I believe we have President Stivers. Sorry, President Stivers.
Thank you, Mr. Chair. Ms. Glisson, I'm somewhat intrigued by this. That this, how long has this been in effect? The statutes that set this up. this system that this bill is attempting to change for our knowledge? Because this is not a realm that I generally get into.
I think what you're finding is that I don't know that there's a specific date. I think this is something that has just been accumulating. The legislature will pass, a statute that says we're going to set up this institution or this entity, and it's going to be housed at a university. And I've been saying for some time, you need to be thinking about, and be more proactive, to Senator Carroll's issue, to say that if the state is asking that this be set up, or that if you're having a contract to house certain data, that we make it clear that this is the state's data, it's our citizens' data, and that the state should own that data and control that data. We're asking them to house that data. But I think what's happened is that this has been a compilation of so many different statutes. There have been contracts through the years, and it never gets addressed. And so if someone just says, possession is 99% of ownership, I've got it, you don't.
And I think it deserves some clarification is data again. What data are we speaking of? In this bill, we're addressing just data that the state has forwarded. Whatever data the university has accumulated on its own, whatever realm, that's their data. We're not trying to get that. We're just trying to get the data that has been referred to them by statutes, contracts with the Commonwealth.
Yes.
I'm going to switch gears here, President, and switch to Senator Givens here.
So that's an intriguing statement. Say this again. You're saying that if a state agency provides the university a data set, all you want back is the data set that was provided? Nothing that the university's collected?
It wouldn't mandate them for that, other than the outcomes we spoke about earlier that are more global in nature. If you want to know, as she mentioned about from the tumor registry, that there's an issue in these particular counties with the pediatric brain tumors, and what medication may be effective for that. Yeah, we would like to have access to that data because it was that information was gleaned from the data we provided. But for the data that the university collects itself from all the other realms, that's their data. We're not trying to access that one.
That's right.
Okay, so the phrasing in here, generated, collected, produced, or created, on line 9. Thank you for your response. I'm just going to take it that you don't want anything the university's produced. Mm-hmm. You just want the data that's been provided by a state agency to the university to be provided by the university back to
yes.
the state agency.
And that particular line you mentioned, I think, Beyond alludes to that and says that. It's generated, collected, produced, or created on behalf of the state agency. No one else.
Okay, thank you.
Thank you.
Senator Williams.
So, to understand it, so if a state agency gave the university data and paid them to look at it and produce some research, you would expect that data is some of the outcomes data that you would expect to come back. Is that tied together?
Well, I think, again, we're talking about the different ways the data is forwarded to the universities. Some of it we do by statute. I think that particular scenario you're talking about would be by contract. So, yes, the outcomes of that contract would be the outcomes they glean from the research.
Thank you.
Seeing no further questions, we do have representatives of the University of Kentucky here to speak against. We will take their testimony. I'm going to give them wide latitude, and then we may circle back to you. Mr. Harden knows how this thing works, so if everyone at the table could, you got to push the green button. If you could state your name and then proceed.
If it's okay with the chairman, I'm going to make a few remarks, and then I'll turn it over to these four individuals and let them identify their name for the record.
Is your mic on?
It appears to be, yes, sir.
Okay. Pull it a little closer if you don't
I'm
mind.
sorry. Is that better?
That's better. Yeah.
Thank you.
Yep. Proceed.
Good morning, Chairman West, members of the Education Committee. First, I want to apologize for President Capilouto not being here this morning. Unfortunately, we're in the middle of a Board of Trustees meeting day.
If you could hold 1 second, can we get these gentlemen a couple chairs so they can sit down? It's a tough committee, but we won't make it stand up the whole time.
Oh, that's quite all right, Chairman. Again, I apologize for the President being unable to attend. We appreciate the opportunity to be here and express our opposition to Senate Bill 66. I think there's a lot of misinformation or confusion around this issue, and hopefully these four individuals at the table with me today can help address some of that. They're going to speak primarily about two specific impacts that we know across campus, one being the cancer registry, which I think former Secretary Glisson spoke of, and then, of course, the Center for Drug and Alcohol Research. But make no mistake, this bill is not limited to necessarily health care or those two areas. It's across the university enterprise. This bill is absolutely not workable in its present form. As all you know, the University of Kentucky is subject to open records requests. And we do our best to conform to those laws. I'm not going to sit here and tell you that we always get it right, because from time to time the courts have told us we don't get it right. But I honestly believe we give our best effort to get it right. Much of the data across the UK enterprise is protected from open records due to the exceptions of the Freedom of Information Act, FERPA, HIPAA, attorney-client privilege data, federal requirements regarding grant research, and certain specific information such as a company's proprietary information that we may be engaged with. An example of that was our recent transaction with King's Daughters Hospital. As currently written, this legislation would often require us to choose between violating state law and violating federal law. In that circumstance, we have no choice but to comply with federal law. We don't desire a conflict with the Attorney General or the federal government. And I don't believe this General Assembly wants to put us in that position either. Now I'm going to turn this over to my four colleagues. I'll let them introduce themselves for the record, and hopefully they can clear some of this misinformation up.
Hello, my name is Jeff Talbert. I'm a professor in the College of Medicine, and I'm the director of the Institute for Biomedical Informatics.
Good morning, everybody. My name is Sharon Walsh, and I'm the director of the Center on Drug and Alcohol Research and the director of the Research Priority Area for Substance Use at UK. I'm a professor of behavioral science, psychiatry, pharmacology, and pharmaceutical sciences. Thank you for having us here this morning.
Good morning. My name is Thomas Tucker. I'm a professor in the Department of Epidemiology at the University of Kentucky. I was the founding chair of that department, and for over 20 years I was the associate director of the Markey Cancer Center, now our only NCI-designated cancer center in the Commonwealth of Kentucky. I also, for over 20 years, served as the director of the Kentucky Cancer Registry, and am currently the senior director for cancer surveillance with the Markey Cancer Center as well.
Good morning. I'm Eric Durbin. I am assistant professor in the Division of Biomedical Informatics in the UK College of Medicine, and I currently serve as the director of the Kentucky Cancer Registry, and I also serve as the director of the Cancer Research Informatics Shared Resource Facility for the UK Markey Cancer Center.
I'm going to talk first today, and then I'll turn it over to my colleagues. I want to start off just by saying I've had contracts with the cabinet in Kentucky since 1997, every year. I've done a lot of work with the cabinet. We continue to do work with the cabinet. And there's not been one time when a cabinet secretary, a commissioner, or someone has asked me for data and we've not provided it for them. And second, we don't store the data at UK and lock it away from the state. We store the data on state servers. So all they have to do is log on to their own state server to get the data that we manage for them. So I think there's been just some misconstrued ways about how this has happened. I'll also add, I was in the same position when Secretary Glisson was in the cabinet. If I wasn't providing her this data, why didn't she fire me or cancel our contract? All right, so let me go through some other comments here. We've reviewed Senate Bill 66 and have a few comments. We don't think this bill is needed and don't fully understand the purpose. Of all the data centers that we operate in collaboration with the state or as a state agent in some circumstances, we already have formal processes in place governed by federal and state regulations to share data. Most have websites with links to formally request the data. For example, in the case of my center, the Institute for Biomedical Informatics, we provide about 250 data requests a year, covering a range of data sets, and we've not once ever denied someone a data set. And we have records of this. We have ticket systems. When you pull a ticket and do a request, it goes in the system. Another case I'll give you, the Cancer Center. They also have a web page that you can do a data request. They've, in the last 5 years, provided 186 data requests, and not once have they denied a data request. In summary, we don't see a need for this bill. We already have a public process in place, and we think that the added burden of having the Attorney General involved in a dispute over what's a limited data set or identified data set is not in the good interest of the university. I'll also add, Secretary Glisson explained to you what a limited data set is. And there's actually 3 types of data sets under HIPAA. One is fully de-identified. That means none of the 18 HIPAA-determined records are in that data set. There's a limited use data set that might have a couple of those fields. For example, let's say I'm doing a drug study and I want to know the date that a person started a particular medication. I need that actual date. And HIPAA de-identification rules say you can't have dates. You have to have blended dates, like a week or a month, or a shifted date. I can request that. And if my request meets some approvals by a research team or by the IRB that it is needed to do the study, then I can have that one field. In no circumstance is a limited use data set raw data. Raw data means fully identified. Names, social security numbers, etc. There's a difference, and it's in federal law. We never have given someone a raw data set as a researcher. One, you don't need it. If you're doing a research project, you don't need to know all that raw data information. And part of HIPAA says the data you ask for that we're going to approve has to be the least identifiable data that's necessary to do the job. And that's the rules that we follow. I'm going to turn it over to Sharon Walsh.
Thank you, Jeff. And thank you again for having us here. So I'll give you some context because there were questions from the committee about how data may be generated under a contract. So, for example, within the Center on Drug and Alcohol Research, we're often called upon by our state colleagues to do evaluations of programs within the state to meet requirements for block grants or other types of activities. We do prospective research studies as well. And all of those data that we collect are protected under HIPAA, but they are even protected further than that because the federal government has recognized that individuals with substance use histories are at even higher risk than other people for having their information divulged. And so there are separate laws within the Code of Federal Regulations that provide extra protections and provide extra stringent requirements on me around what I actually am able to share for those people with substance use disorders or those people with HIV. We are very cognizant of the fact that our business is research, and research is meaningless unless we disseminate it. And so we want always to share the data as broadly as we can, at the same time being compliant with all the regulations that provide the oversight and for which we're required to comply. So I can tell you that, I can give you an example where somebody may reach out to us and say, I'd like to see the data from this study that's going to identify everybody that was in a particular treatment program receiving substance use services in the state. And I can say to them, I'm not able to give you that information. And what we could do is we could look at what kind of limited information under the law that we can provide, and we'll share that with you. That's not always what people want, I will tell you that. And it may be that some people don't understand what the regulations are. The other thing that guides this is that when we enroll people into a treatment program or into a research study, they sign a consent form. And that consent form is under the regulations of the Office of Human Research Protections at the federal government. It tells all of the elements that have to be in that informed consent form. If you've gone to the doctor, sometimes they're 7 or 8 pages long and they seem kind of excessive, but that's because of the requirements of the information that you need to share with that individual. In that consent form, it says exactly who the data can be shared with. And if an entity comes after the fact asking to see all of your data and someone has not given their consent for it to be shared, that is another issue that we need to address. Sometimes it can't be circumvented because it's not possible to go back and seek consent from everybody that was in something 4 or 5 years ago, as an example. So I think that there is a lot of misunderstanding around how the laws work, and also who owns the data. So the university doesn't own the data that the state supports. In some cases, and this is the case in the Center on Drug and Alcohol Research, we collect data on behalf of other agencies as well. And so there may be support from the state, but there may also be another data owner that's outside of the university, and we have to comply with what they request. One of the things that Dr. Talbert didn't mention is that any contract that we enter into has a data use agreement, and it specifies all of the ways in which we are not allowed to share the data, and the DUA, that data use agreement, is coming from the state cabinet. Thank you.
Eric, why don't you go ahead first?
Good morning, and I appreciate the opportunity to speak to you today. And I wish we could be better prepared. I actually learned about this bill myself yesterday, and I was attending my father with his chemotherapy treatment this morning, and we literally sped here to make the committee meeting this morning. And I think we're fortunate that we made it in one piece, quite honestly. But again, appreciate the opportunity to be here. So there were several things that were said, and so please ask follow-up questions if I've left something out. There was a point about childhood brain cancer in Kentucky, and that's actually a very important issue to us at the Kentucky Cancer Registry. In fact, we identified a number of years ago that there appear to be high rates of brain tumors in Kentucky children, and we conducted a broader study looking at throughout Appalachia. Since then, through the Kentucky Pediatric Cancer Research Trust Fund, we were able to obtain resources that helped facilitate taking a very close look at the brain cancer rates within Kentucky. When we look at the state, there's a wide area in eastern Kentucky where the rates are higher, and then there's also what we would term a cluster in the north central region of the state. And in fact, we have made our childhood cancer data, summary data, of course, publicly available. In fact, I was here yesterday in sharing our annual report of Childhood Cancer Kentucky with a number of members on the committee who are here today, and I would be more than happy to answer any questions about those incidence rates. So the way we handle a cluster investigation, and honestly, we don't get a lot, but we do get them from time to time. In fact, there was recently a request. There was a family that reported that their child and 2 other children that lived along a creek that was somewhere close to Ashland, Kentucky. It was very close to the West Virginia border. That they felt that there was an uncanny number of cases there, and the way we deal with these cluster investigations is we contact the Department for Health and Family Services, the state epidemiologist, Kathleen Winter, and in this case, which we did, and we shared with Kathleen all the information that we had for the entire county surrounding this area. And I will admit, on the surface, it looked like there may have been an issue there, but when we conducted statistical analysis in collaboration with the department, we didn't have the statistical evidence that there was a cluster. But we take these things very seriously, and we jumped on this immediately and immediately provided the data set to answer this question. So let's see. There were a number of other issues. So yeah, and so there
as a whole, we got about a couple more minutes. Is all we have in this segment. So.
Okay,
you're fine. You're fine.
I'll try to make this quick. So there was a question about oncologists coming to the registry for medical records. So let me be clear that the Cancer Registry reviews medical records, but we are not a medical record. That is not what we do. We're collecting data for public health. And in general, for most of the information that we gather, we have certified tumor registrars, professionals who log in to medical record systems, review data, and summarize and abstract that data into a record. So, in fact, if we tried to provide an oncologist with drugs that a patient had been exposed to, we wouldn't necessarily have the specific agents or the modality of treatment, and it could actually put a patient in danger if that was used to make a decision about how to further treat a patient. So, but patients and oncologists are free to come to us with requests for data. We actually have a formal process. A patient can fill out a form, and if they get that form notarized so that we know that it's actually the individual requesting the data, we readily provide those records. And we don't get a lot of requests of that nature, but we're more than happy to provide that. I mean, my perspective is these are in fact the Commonwealth's data. These are the data of the citizens of the Commonwealth of Kentucky, and we do everything in our power to make these data valuable and available to all that come to us with these requests. And as Dr. Talbert indicated, I have a formal record of 186 requests for data from researchers, and those researchers are at the University of Kentucky, the University of Louisville, and a number of institutions outside of the state of Kentucky.
So let me just really quickly, because I know you have limited time. First of all, I want to make it clear that the Kentucky Cancer Registry was established by the General Assembly. And over the nearly 30 years it's been in place, we have made the Commonwealth of Kentucky quite proud. It is considered one of the best surveillance systems, not just in the United States, but in the world. And there's documentation for all of that. We are honor-bound to operate under the statutorial limitations that are outlined in the law that creates the registry. We have created a system for releasing data appropriately under those guidelines and within state and federal law. We have presented that. Actually, we met multiple times with Secretary Glisson when she was Secretary of the Cabinet of Health and Family Services, and went through this with her and volunteered to help her submit the application. We have no record of that application ever coming to the registry. Now, I want to make it clear that it's a little disingenuous from my standpoint when the state places the registry at the University of Kentucky because the expertise to actually manage a very complex and intricate data set. Cancer is not one thing. It's hundreds of different diseases classified together. We've made that very proud, but we are the designated agent of the state. The fact that we're at the University of Kentucky makes us no less the designated agent of the state, and we have always operated with honor in that vein. I want to just conclude by saying we have got the funding for this from outside the state. We have, over the years, more than $75 million have come into the economy of Kentucky through the National Cancer Institute and the Centers for Disease Control funding. And using this as a platform, as Dr. Durbin has said, and reviewing appropriate applications for access to the data for research while protecting human subjects, which we have done, we have had multiple grants come from, again, outside the university into the state economy with many, many more millions of dollars. And we have some records about using that registry to be the key for identifying why we had the highest colorectal cancer incidence rate 20 years ago. We wouldn't have seen it without that registry that you created. And we have used that and leveraged that, and over the years we were able to foster many screening programs using that data, and now we don't have the highest colorectal cancer incidence rate. There's been a 30% decrease in that incidence rate. And let me put it in perspective. A 30% decrease in that rate because you established that registry means that every single year now, 650 Kentuckians aren't diagnosed with colorectal cancer anymore. That is an amazing accomplishment. The bill that's proposed, we are concerned, would be damaging to that, and we therefore oppose its passage.
Thank you so much. We are very tight on time now, so if Senator Meredith and Secretary Glisson could come back up, you've got about 2 minutes to respond. And then we have to vote. So, thank you, UK and your representatives.
Thank you, Mr. Chair. Very interesting discussion. I think it's interesting, though, that University of Kentucky's position is there is no problem. Obviously, we've given you some anecdotal experiences where we think there is a problem. So who's telling the truth here? Who knows? So who's going to be the arbiter in this situation? Who should be the arbiter in this situation? If University of Kentucky or any other university is doing what they say they're doing, this bill is not of consequence to anybody. But if they are being remiss in releasing data, what recourse does any other person have to challenge that? There's not any. University gets the final word on who gets our data. Again, this is not an indictment of the work that the university has done. It's a great university, great research projects. But we get back to the basic issue of who owns this data, who should have access to it, and they're the gatekeeper of this, and I think that's inappropriate.
And I just want to reiterate that all this bill does is to try to make it clear that the state has access to its state data. It's housed there. It's only the state's information and the state's data. And we're asking that be able to be accessible by the state and researchers only in these limited circumstances that obviously are going to be under state and federal law. I do not want to get you confused about I only answered Senator Thomas's question about the cancer registry. This does not address that issue. This is just about getting the state's data back that it has housed there. That is a whole separate issue. And to, I guess it was Dr. Tucker's comment about I didn't sign an application. I'll tell you why I didn't sign an application. It's because I was asked by Dr. Capilouto to come to see him about this issue, and I was pushing back, and I said, I don't have any data. It's not just cancer data, it's all kinds of data that is put together from this cabinet, and I don't have any access to it, and I'm having all these barriers are being put in front of me. So we met, he was very kind. He brought his head of the research institute or his research area in to meet with me. He said for us to work together, and what I got was the repeated document that said, before we can give you this access, you have to agree that we own the state's data. And I said, I cannot sign that. I don't believe that. I've looked everywhere. I don't think you own it. So I did not sign an application because I was not going to waive the state's right to its data.
We have one question that'll have to be the end of this conversation. Evans.
Mr. Chairman, thanks for engaging me in one more question. And Secretary Glisson, this goes to something you said earlier that's intriguing to me. I'm trying to find a way forward.
Me too.
This is a tremendously complex issue. we've got professionals there that seem to know exactly what they're talking about. I have no doubt of your passion for the issue. And I'm sincere in respecting my colleague that's brought the legislation. So I'd love to find a way forward. Earlier in your testimony, you touched on something that I think could be a possibility. A complaint and adjudication process. If you've got a complaint about lack of access to data, let's consider the chairman and my colleague, the bill sponsor, is the one to determine this, but this could be turned into a complaint and adjudication process whereby we find the way forward in those circumstances where we can, and in those places we can't, we have someone that weighs the merits of both. Just an idea to think about.
Yeah.
Thank you.
I appreciate that, and I think that's why we maybe suggested that the Attorney General that has a way to oversee this could be sort of serve in that role. But if there's other ways to do that, and to your issue, Senator Givens, I think I made these comments. What I heard about the concerns that from UK were that we can work with you. We can, if you want a statement in there that says we're going to comply with all state and federal laws, I don't have a problem with that. Obviously, we want to always do that. So I would suggest that we have a chance to hear. I would like for this bill to pass out of this committee. Give us an opportunity to work with the University of Kentucky. I didn't hear anything here that I don't think we can't address, and then come back to you after we've been able to work through some of the, if they have any issues, that we can try to work through those.
Thank you so much. It's time to vote. Do we have a motion on the bill? I'll make a motion. Do we have a second? Second. Mariah, please call the roll.
Senator Carroll.
Let's explain my vote, Mr. Chairman.
Please proceed.
Two credible sources came to the table today. That room we always talk about putting people in and leaving them there until they get things worked out, that's where you all need to go. Thank you, Mr. Chairman.
Senator Funke Fromeyer.
I feel such great respect in recognizing that I'm a freshman, and I have to acknowledge that this incredible diligence and credibility that we experience from Senator Meredith and our cabinet secretary, along with the experts from University of Kentucky, I can't vote yes or no, so I have to abstain.
Is that a pass vote?
Yes, that's a pass vote.
Thank you.
Senator Givens.
Pass.
Senator Higdon. Senator Meredith.
Aye.
Senator Neal.
Pass.
Senator Stivers.
Please proceed.
I'm going to vote yes, but it appears there are some very serious concerns, and that this is not ripe for this bill to come to the floor yet with the concerns that have been raised, but to continue a dialogue, because I see a lot of problems now looking at the bill with lack of language in conflict with federal law. So with that, I'm going to vote aye.
Senator Thomas.
I'm going to vote no and explain my no vote. I think you have to read the words on the page. And again, as I said when I questioned Secretary Glisson, if you read the definition of data, there's no exclusion or prohibition whatsoever of personally identifiable information. That just reeks of violations that we time on in regard to HIPAA, our privacy with our medical information. But this language, if it became law, could allow individuals provide their personal information about that. As we heard from the experts here, oftentimes that is something that's held sacred even when you share information, the personally identifiable information of an individual. For that reason, I am going to vote no on this bill.
Senator Tishner.
I'm going to pass, and I'd like to explain that.
Please proceed.
Thank you. On the one hand, we have information that is state data being provided to the University of Kentucky. And on the other hand, the University of Kentucky is very concerned about privacy of that data and that information. And I think there's too much on the table here that needs to be explained. And for it to make its way out of committee and to the floor with that much unexplained, to leave this many of us up here confused about this bill, I think it needs to have a little bit more work done and perhaps make it back through committee. Thank you.
Senator Williams?
I'd like to explain my yes vote.
Please proceed.
I think if this bill does not make it out of committee, then these two parties are going to go their separate ways and they won't be compelled to get into the room. But I think if we pass this out, it will go to the Senate, at which case I believe both parties will come together, come to some sort of agreement. Maybe they can do it while it's in rules, or it can be referred to another committee, perhaps judiciary or health, that might have a better handle on these issues, and they can move forward. So I'm voting aye to encourage the two parties to get together moving forward on that. And that's why we also have a bicameral legislature. This is just the beginning of the process.
Senator Wilson? Aye. Senator Wise?
Explain my vote.
Please proceed.
I'm going to also vote aye. It is a part of the process. This is not the first time in committees that we've had legislation that many forward, and continue to see both parties working on another version of the bill. I appreciate all sides today that provided testimony on the bill. I will vote aye.
Chair West?
Aye. Explain my vote. My vote explanation is much like Senator Wise and Senator Williams. UK knows how this process works. Senator Meredith knows how this works. This is just the beginning, and that's my aye vote. The committee would stand at ease. Seven aye votes, 1 no vote, 4 pass votes. Senate Bill 66 passes with favorable expression. Thank you.
Thank you, Mr. Chair, and thank you, members of the committee.
Thank you.
Next, we have Senate Bill 107. Senator Wilson, we have a sub and a title amendment. Do you want us to take care of those first?
I believe we have to take care of the title amendment afterwards, after the vote. But,
it's almost like you've been chairman before.
I'd like for a motion on the sub.
I'll make a motion on the sub to adopt the sub. Do we have a second? Second. We have a motion and a second. All those in favor? Aye.
Aye.
Those opposed? Ayes have it. You have before you Senate Bill 107 with committee sub. Please proceed.
Thank you, Mr. Chairman, members of the committee. One of the things I want to point out to start with, this bill is about removing the politics out of the Board of Education. It is something that we have been working on for a long time. And actually, I've seen the Board of Education be utilized outside of the governor's office as if it belongs to him. And I've seen it all 3 times that I've been here under 3 different governors. That has happened. Actually, the Board of Education, the Department of Education, is a creature of statute. They were created by us, and they are governed by the regulations and rules that start from the laws that we create. We actually fund them. So when we look at the Constitution, who has the responsibility for education in the state? It is the General Assembly. We are charged with that. And so what this does, and I will say that we saw, I think, a real abuse of the power of the governor's office when he took and The Board of Education, he actually wiped it out and reconstituted it and then appointed everybody that he wanted on it. So it came to us to actually do a law that said he couldn't do that anymore. This goes a little bit further, and what it does, it creates a education nominating committee. And the governor is going to appoint these folks from the 7 different Supreme Court districts. They will be appointed by the governor, but then these nominating committee will actually be the ones that will actually vet the nominees for the Board of Education. And they will vet for each different vacancy on the board, they will vet 3 people that will be presented to him, and he shall choose one of those people for that position on the Board of Education. It creates one more step that has to be balanced the same way the Kentucky Board now has to be balanced by the 2 major political parties, representation there by the 2 sexes. It has to be balanced in regards to the minority composition of our state. As you look at this, there are things that are laid out as how those boards have to be balanced. This is very similar, if not almost exactly, what we did for the university boards when we tried to remove the politics out of the boards all the way around, because we saw the previous governor had appointed all these boards and they were not balanced in any way politically or racially or any of those things. And so we've done a lot of work on this, trying to remove politics, because we created the Board of Education, and education itself was created to be outside of the governor's office. It was created to be an independent entity that would not be influenced by politics, but yet we've seen that happen over and over again. The only other thing that you will see is that we are prohibiting in this bill on page 4, ex officio and other non-voting members shall not be represented by proxy at any meeting of the board. Then lastly, what we do with the commissioner, we make the commissioner have to be confirmed by the Senate. He will be subject to a 4-year term, which our current commissioner is. His term comes up, I believe, in September of next year. And he will be subject to reappointment by the Senate. I think this is something, we've already done this with Fish and Wildlife. Now, commissioner has to be confirmed by the Senate. And in the same way, that's what this bill does. Very simple bill, in my opinion.
Thank you, Senator Wilson. Do we have any questions on Senate Bill 107?
Motion.
Seeing none, we will proceed to vote. Do we have a motion on the bill? We have a second from Senator Funky. Okay, we have a motion and a second. Please call the roll.
Senator Carroll.
Aye.
Senator Funky Fromeyer.
Aye.
Senator Givens.
Aye.
Senator Higdon. Senator Meredith.
Aye.
Senator Neal. Senator Stivers.
Aye.
Senator Thomas.
No.
Senator Tishner. Senator Williams.
Aye.
Senator Wilson.
Aye.
Senator Wise.
Aye.
Chair West.
Aye. Senate Bill 107 passes with 10 ayes, 1 nay vote. We will circle back here. Senator Neal, if you would go ahead and vote for the record. Senate Bill 107 passes with favorable expression with 10 aye votes and 2 nay votes. We have a title amendment.
Yes, sir.
I'll make a motion on the title amendment. Do we have a second? All those in favor of the title amendment say aye.
Aye.
All those opposed? Ayes have it. Senate Bill 107 passes as amended by Senate Committee Sub and title amendment. Thank you, Senator Wilson.
Mr. Chairman, if I could, I was absent when the vote was taken on Senate Bill 70. I'd like to register an aye vote for that.
Duly noted. Thank you. Next, we have, as our final bill of the day, Senate Bill 150. If Senator Wise would approach the table.
Mr. Chairman, may I be recognized to cast a vote?
Please proceed.
I was away from committee when the vote was taken on Senate Bill 70, and I wish to be recorded as an aye vote.
Duly noted. As Senator Wise is preparing to testify, I need to make an announcement on Senate Bill 150. The committee will stand at ease for one moment. We are just addressing the Senate committee sub on 150. Senator Wise, his remarks will be only to the committee sub. Senate Bill 150 passed in a prior committee meeting, and we will not be addressing any of the items that we've already covered. All members, you do have the committee sub in your packets, and so that's what we're addressing today. So if you could please identify yourself for the record and proceed.
Thank you, Mr. Chairman, members of the committee. Max Wise, State Senator of the 16th Senate District. Members of the committee, you will find in front of you in your packets committee sub for some technical corrections and some additions that are being put forth in Senate Bill 150, an act relating to rights in public schools. I'm going to go ahead and get right into, since we have already voted on Senate Bill 150 by 11-1 vote, but here are the changes in the committee sub, if you would follow those along with me, if you choose to do so. Section 1 of 2, which is found on page 1 of the committee sub, narrows the focus for each school district to list for parents the health and mental health services related to human sexuality, contraception, or family planning. If you then flip to page 3 of the sub, section 1, subsection 6 of the entirety of that would require parents access, review, and consent before any well-being assessment or survey is administered to a student. And lastly, the sub adds in there, same page, subsection 7B, which of concerns that were raised in this committee, as well as other members in the Senate, that would reinforce KRS Statute 620.030 and KRS 600.020, 1A, that says regarding the duty of school personnel to report abuse or neglect if they have reasonable cause to believe there is a risk of injury. So what is found there in B has also been added. Mr. Chairman, I first would like to move for adoption of the sub, since I've explained it, and then if I wish to have any questions as it relates to the sub.
Are you making the motion yourself?
Can.
Second.
We have a motion and a second on the sub. All those in favor say aye. All those opposed? Ayes have it. The Senate Committee sub is now attached to Senate Bill 150. There are no title amendments. We have a motion on the bill. Before we get to that, we will accept a few questions. We are tight on time. Senator Thomas.
Mr. Chair, I just want to understand your prefatory comments before we began discussion of Senate Bill 150. Are we not allowed to ask questions on the bill that's going to come before the floor? Because this bill is going to come before the floor. And so, therefore, I would think it'd be appropriate to have discussions on the bill that's going to come before the floor, as opposed to just the changes that were made in the Senate Committee sub. So I want to get some clarification on that.
If we could keep it tight, we're almost out of time. We have 6 people to speak against the sub. So if you could ask your question, keep it tight. I mean, you could try to stay on track as best you can, please.
I appreciate that. Senator Wise, I want to refer you once again, because I noticed one of the changes that you did not make is on page 2. We're in section 1. Subparagraph 5, B and C. It seems to me that you kept in the provisions that, 1, the Kentucky Board of Education or the Kentucky Department of Education cannot require, recommend policies dealing with pronouns or the use of pronouns that conform to the child's choice as to the biological sex that they identify. And that same prohibition also applies to local school districts, that they can't require school personnel, that seems very broad, that would include administrators, counselors, and teachers, to use pronouns that the child would recommend or prefer as to their identity of choice. You did not make those changes. Why not?
The only changes that were made is what I've testified before already of what the committee sub has before you.
In keeping with my words with the Senate Chair, then my second and final question is this. It seems to me that what your bill would still permit, and correct me if I'm wrong, please correct me if I'm wrong, that even if you have a child whose parents support that child, who say, I support my child's own identity and choice, that neither the State Board of Education, neither the Kentucky Department of Education, and neither the school board could prevent a teacher or an administrator from calling that child out of that preference. And if that's the case, it seems to me that we are allowing intimidation, harassment, and or bullying of that child by adults with regard to educators, licensed educators, with respect to that child's identity choice.
Nothing in this bill would prevent students from requesting identification for a non-birth conforming pronoun, nor prevent staff and students from addressing those students with non-conforming pronouns. It allows still for the First Amendment, for faculty, for those wishing to do so or not, up to them. But there is nothing in this bill. Nothing in this bill. There is a lot of misinformation, a lot of things that are out there right now with other bills. You have before you Senate Bill 150, the text of the bill, of what is there and what has already been voted on already by this committee. It's simply with this is the changes that have been added with the committee sub.
Thank you, Senator Thomas. We need to really move on here. We're going to have Rebecca Blankenship up first. Yes. We're going to follow the same protocols as our last meeting. So if you could, please keep it to 2 minutes or less.
Sure thing. Hello again.
And let me, before you start, clarify one more thing we're doing. So the same rules would apply to those speaking against as to the bill sponsor. So we're just talking about the sub. So if you could just make your comments related to the sub, please.
Yes, sir. So again, my name is Rebecca Blankenship. I'm the Executive Director of Band Conversion Therapy Kentucky. I'm back to talk about the legal corrections that were made, which Senator Wise referred to. In our opinion, those are inadequate and that a conflict in the law still exists. So as Senator Thomas pointed out, in particular, it's that 5C section of the bill that creates a conflict in the law in two ways. Well, more than two, but two big ones. The first is that it effectively, as I mentioned last time, requires teachers to divulge their personal beliefs concerning LGBT issues. The First Amendment is not something that applies to grade school teachers. It is not appropriate for somebody who is acting as an agent of the state to be required to divulge their personal beliefs or speak on their personal beliefs while operating in that professional capacity. The state has created, and the federal government has created, laws that particularly prohibit teachers from doing that in order to require them to behave in a particular way and to offer them the shield of liability that comes, the shield from liability that comes with being an agent of the state. This committee sub does not correct that. And it also does not correct the conflict in law that results, as Senator Thomas pointed out, by permitting teachers to engage in bullying and harassing behavior. Regardless of whether, and I think that there can be some debate, or certainly there is some debate about whether misgendering constitutes bullying and harassing behavior. At the very least, this law does not clarify what is already established, which is that that this has been viewed as bullying and harassing behavior. So it's the teachers deserve to have clarity, students deserve to have their freedom of conscience respected, and parents deserve to have their personal beliefs respected by teachers as well. Thank you.
Thank you. Next we have Jessica. You can correct me as you come up. Jessica Bruner. I may have that. Bowman. I'm sorry. I could not read the list here. 2 minutes and direct it to the sub. Thank you.
Okay. I had to regroup a little bit, but hopefully I can do that. Today I'm wearing a Proud of My Daughter shirt. There was a time when my queer kid may not have felt that from me. When she was 15, she came out to me as gay, and I was not the affirming parent I am now. I said things like, it's a phase, and blamed who she hung out with. I let my fear of how she would be treated, what other people might think, and all the unknowns impact the way I treated my child. This bill, even with the sub, still outs kids with complete disregard for what they are going home to. It specifically says a history of violence. Not all households have a history of violence until their kid comes out. Kentucky currently ranks in the top 5 for child abuse. LGBTQ youth are 50% of all homeless youth, even though they do not come close to making up 50% of all youth. My home wasn't at first affirming, not abusive, and yet my reaction still harmed my kid. She still had suicidality. This bill will kill kids. I also want to address, parents' rights. I have a right for my child to go to school in a safe and learning environment. While it may give teachers the permission to use correct gender and name, it also doesn't clarify that teachers don't have permission to use the wrong name and gender. This is legalized bullying by peers and their teachers. And I don't know if you know, but our schools have a bullying problem already. And kids are killing themselves at record numbers. This bill is not popular with Kentuckians. We do not want a state that is mean to kids. Please vote no on Senate Bill 150.
Bob Hellringer.
Thank you, Mr. Chairman.
You've been here before
Sure
a few times.
Roll call on that. Thank you, Mr. Chairman, members of the committee. For the record, I'm Bob Hellringer. Live at 3703 Hanover Road, Louisville, Kentucky. That's in the 19th Senate District, so I don't have any senator as of today. We're going to take care of that next week. I indicated an interest in running for that, Mr. Chairman, and the chairman of our party said, well, Bob, no thanks. We actually have some thought of winning that seat. He smiled when he said it. Anyway, I'm here. I do represent the Fairness Campaign, but I'm really here as an individual. As a former Republican state representative, I served with some of you here, gentlemen back there. Glad to see you. There's a second act in politics. Senator Williams is going to do a great job here. I know that because I served with him. It's just distressing to me to see the amount of legislation, not just this bill, this pronoun bill, but bills in the House, House Bill 30, 58, 120, bathroom bills, conscience clause, so people don't have to treat transgender kids if they don't want to, can discriminate against them, what kind of treatment they can have or can't have. Why are we singling these people out? How many people are we talking about? How many transgender kids are there in the state that is so deserving of this kind of attention, okay? That's pure discrimination. That's all this is. I would think the legislature has so much more to do in education than to have a pronoun law. I mean, I'm just reading this. Pronouns that do not conform to a student's biological sex as indicated on the student's original unedited birth certificate. Why is that any business of the General Assembly? Why don't let the schools handle this? Why not let the families handle this? But the General Assembly has to handle it. Haven't these kids had enough challenges? Then have the school have to say, I can't call you he or him. You're going to have to be her or she because the state government said so. I think it's wrong. There's either right or wrong, and this is wrong. And you know what? It's not just discrimination. It's not just immoral, in my opinion, but it's not going to work, okay? You're not going to take people who, for some reason, you don't approve of what's happened to them as if they had any choice over that. You don't approve of them or some of their lifestyle. What's next? You're going to tell them how they can dress when they come to school, what subjects they can take. What's next after all these other bills? It's just flat wrong, and it's not going to work. You're not going to drive transgender kids or gay people in general back into the closet, back into the shadows. Thank God they've come out from that, okay? And they deserve to live as freedom-loving Kentuckians like you and me, and not have to worry and hire people like me to come up here and try to talk you out of passing a pronoun bill. We got thousands of students in Kentucky in Louisville that can't read at grade level, can't do math within 2 grade levels, don't have homes. There ought to be a charter school in every neighborhood in Louisville. I know you're working on that, okay? And we ought to get the constitutional amendment passed to reverse that unfortunate Supreme Court decision that took away the educational opportunity grants. We need those kind of reforms desperately in Louisville, but instead we don't even going to post the constitutional amendment, but we have time for 2 hearings on pronouns. Think about what you're doing, okay? Is it right or is it wrong? Is it right or wrong to punish these poor, powerless, defenseless children and their families, okay? It's been an honor to sit here. Thank you, Mr. Chairman.
Thank you. I'd like to note that you got double the time as a former representative. 4 minutes. That's right. Mason Chernowski. State your name and please proceed.
Mason Chernowski. A week ago, I came to speak in opposition to this bill. I spoke about my personal battles with mental health as a student in high school and how not being able to access LGBTQ affirming services at my school affected my mental health, where my peers who were able to access services got better. These services specifically mean services around contraception, sexuality, and family planning, the ones that are outlined in the sub to this bill. As a student, I learned that I had equal rights under the law, and I believe I should have had the right to equal accesses for those services. My opinion on this bill has not changed. I do not believe that the new change to the bill goes far enough to protect our kids' mental health. Policies like the one this bill proposes would have made my life worse. It will make life worse for students in our Commonwealth. Since I testified, I have heard about trans kids who have attempted suicide, who have had their mental health be worse, who are considering suicide as a result of these bills. Some of you on this committee spoke last time that you care about trans people, that you know trans people in your life personally, and that you don't want to see harm come to them. You've heard from us so many times how harmful this bill would be. Please do the right thing. Please uphold the rights of students along with teachers. Please demand that more changes be made to this bill so that we can actually protect the students that you all care about. Thank you.
Next we have Chris Hartman. State your name, please proceed.
Mr. Chairman, thank you. Chris Hartman, he, him pronouns, Executive Director of the Fairness Campaign. There's not much of my voice left, or me left today, after wrangling more than 300 Kentucky fairness and LGBTQ rights supporters in the Capitol yesterday. I know you saw them. I certainly know you heard them. But I know you saw them. And I know you saw our young people. Perfect, whole, divine, made in the image of God, who are terrified that you will take away their basic dignity and respect. And to do it in front of Karen Berg is a sin and a shame. We loved her son, Henry, who came up here. The reason he had to come up here in the first place when he was 15 years old, 15 years old, interning for the Fairness Campaign as a high schooler, was to testify against a bathroom bill. Weary peas, you're legislating where these people can survive. And I'll tell you what, they can't. They cannot with the slate of hate that you all have introduced this session. The suicide rates are outrageous. You know it. You seem to not care. Not a one of you have talked about it. What is the intent of this bill? What is the point? I'll send you all the Journal of Adolescent Health article that I referenced last time so that you all can have it before you vote on the floor today. To know once again that nearly 50% of our queer kids have thought about suicide and nearly 20% of the trans kids have attempted it. And that just having one place where they are respected for who they are will reduce that chance of suicide by more than 50%. Shame on you all!
Next up, we have, I could be wrong on this name, Larry W. Bell, I believe.
I didn't sign up to speak.
Okay. Okay, duly noted. So that was the last speaker in line. So we will proceed to a vote. We have to backtrack a little bit. We have a motion from Senator Stivers on the bill. We do not at this time have a second. Do we have a second? We have a motion and a second. Please call the roll.
Senator Carroll.
Aye.
Senator Funke Fromeyer.
Explain my vote, please.
1 minute, please proceed.
Yes, I do want to acknowledge that I vote aye on this bill in love and support of children and of parents.
Senator Givens.
Aye.
Senator Higdon. Senator Meredith.
Please proceed. 1 minute or less.
Thank you. Well, what I've learned today for several of these bills is we all need to do a better job of communicating, talking. I think it's interesting that the bill that I presented earlier, we kind of put a pause on to work out the differences and what my bill in the University of Kentucky wanted. And I think this one is eerily similar. We need to have a lot of dialogue. And I respect the emotion that has been brought to this, but I'm not sure that the concerns of other folks are being equally considered. And I'm not saying those concerns are right or wrong. It's just they should be considered. We should be able to sit down at the table together and talk about the right approach to all these things. I'd like to hear a little bit more from our educators, the teachers in the classroom about this. And I think it's just premature at this point in time to act on this bill, so I'll vote no.
Senator Neal.
I'd like to explain my no vote.
Please proceed.
I agree with Senator Meredith and his comments. I think they're very important. Quite often, those of us that sit in these seats, we know what's right and wrong, or so we say, or so we think. I think sometimes because you have power doesn't mean you exercise it. Should you exercise it? This is one of the cases that is so clear to me that it's inappropriate to go down this road. I cast no aspersions to neither the sponsor or anyone else, but this is so inappropriate. I don't know any other way to express it. These are the mildest terms I can use. We have to do a better job. Our responsibility is too awesome. But you know what? We have a responsibility to protect the smallest, less empowered, threatened, vulnerable individuals, no matter who they are. They own their space, and we should not invade it. No.
Senator Stivers? Senator Thomas?
Mr. Chair, I'd like to explain my no vote.
Please proceed.
One of the things we know how to do very well in this legislature is to impose mandates on teachers. I think all teachers would say that they are given a lot of mandates what to do except the mandate to teach. But in this particular instance, it's amazing, but really sort of sinister that we don't impose a mandate on teachers in this instance, requiring them to call a child by the noun or pronoun that they prefer. And it's interesting, also somewhat contradictory that we style this as a parents' right bill, but we're actually stripping parents who agree with their child's transgender from exercising those rights. The parents can go to the teacher and say, or the school principal say, I want my child to be called by the pronoun they prefer. But they don't have that right to do so. Parents don't have the right to protect their children under this bill. There are several reasons I could also name, but in the interest of time, so I only have 1 minute. Those are two of the reasons why I vote no on this bill, and I really hope it doesn't pass this legislature.
Senator Tishner?
I'm going to vote yes, and I'm going to just a minute to explain my vote, please.
Please proceed.
This is a bill about parental consent. This is a bill about making sure parents know if their kids are suicidal regarding this issue, a parent should be made aware of that. And for you, sir, to come up and accuse us of not caring about Senator Berg is... A parent needs to know if their child is suicidal. This is about parental consent. And I vote yes.
No comments from the audience.
Senator Williams?
Yes.
Senator Wilson?
Aye.
Senator Wise?
Aye. I'd like to explain my vote.
Please proceed.
There is nothing in this bill mandating as it relates to pronouns. There is still the choice for teachers wishing to choose to do so, a student still requesting to do so. There's also nothing in this bill that does not allow for nicknames, alternative names, if a teacher still has the belief to use those. This is about, once again, parental communication. And even today, I spoke in the rotunda as related to empowering parents, having parental rights, and for them to have communication, to have transparency with curriculum, to allow those parents to have the opportunity to look things over. This, once again, is about parental communication. Thank you, Mr. Chairman.
Chair West?
Aye. Senate Bill 150, as amended by Senate Committee Substitute, passes with favorable expression of a vote of 9 aye votes and 3 no votes.
Shame! 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 Shame!
The business of this committee is over. Thank you.
Just killed kids.